Hi, everyone. Good morning, everyone. This is Ifama Odunlami, immigration attorney from the Odunlami Law Firm in Cedar Knolls, New Jersey. Hi, everyone. As you come in, please let me know that you're here. Say hello and tell me where you're joining in from. So today I have a really great topic, and this topic I chose it based on the consultations I've been having, the issues people have been having, and I just want to make sure that I'm addressing, I guess, the issues people are having. So for those that don't know me, my name is Ifama Odunlami. I'm an immigration attorney from the Odunlami Law Firm in New Jersey, but our firm serves clients in all 50 states. And please feel free to subscribe to my channel, Facebook, Instagram, YouTube, and LinkedIn, TikTok. So I'm actually right now on Facebook, Instagram, and YouTube. So I'm going to be looking back and forth because I'm on different screens. So today I'm excited to talk about some of the successes we've gotten. Like in the past few weeks, we've gotten a lot of success in cases that we filed that have been, we've gotten responses rather quickly. Now, all of you know that USCIS has experienced significant backlogs, right? These backlogs, well, sometimes have always been there. They were there before COVID, but COVID made it worse. So we have people with cases that have been lingering for a year, 2 years, 3 years. And as an immigrant myself, I know how frustrating it is for you to have a case you're trying to file for a family member, nothing's happening, you can't work, you can't do the things you need to do, you can't travel. Sometimes you have family members who are sick in your country and you can't go to see them. It is so frustrating. I understand it. So today my topic is 5 ways to speed up your immigration process. That's the topic. So let me see. Let me go to my comments, see if anyone's here. No one's here yet. So we're going to talk about 5 ways to speed up your immigration process. But frankly, the best way is the last way, which is the most successful, which is filing a lawsuit against the government. I know that sounds really scary, but you're filing a lawsuit against USCIS. We have done this with tremendous success for our clients. As a matter of fact, when we file a lawsuit against USCIS for unreasonable delays in a case, right, within a week, we get a response. So the one we did recently, I think was a week ago, in less than a week, the I-130 was approved. This is an I-130 that had been pending for almost 4 years. My client filed for his spouse who lived abroad, and for almost 4 years, he had heard nothing, no approval, nothing. He had called USCIS, written letters, contacted the congressman, done everything. And as a matter of fact, when he came to us to represent him, which was, maybe a month before, just a month ago, we also got on a call with USCIS to see if we could assist him in moving the case along, because we just wanted to know what's going on. It's not normal for you to file an I-130 case that has not been approved in almost 4 years. That's not normal. So we wanted to know what's going on. We knew that the case was still active, but there was no information. So finally, we did everything else. We did the Congressional Assistance, everything, and I said to the client, if you want your case to move along, you're going to have to sue USCIS. And I've made these suggestions to many clients, but they're afraid. They're afraid of retaliation. And he was afraid of retaliation as well. But I said, there is no retaliation. This is us trying to figure out what's going on with your case. And within a week of filing, the I-130 was approved. Now, I want you to understand that the filing is not what approves the petition. It basically gets them to doing what they're supposed to do. And in this case, it appears that they were going to approve the I-130, but somehow, somewhere, that case got lost. So when we filed a lawsuit, they went ahead, pulled the case, and did the work they were supposed to do. So top of the list, if you're looking to move your case, is to file what we call a writ of mandamus against USCIS if your case has experienced unreasonable delays, right? And how do you know the delay is unreasonable, where there's a case processing link that I'll put below after I get off, which tells you how long it's supposed to take your case. How long it's supposed to take your case. So if you file an I-130, it tells you how long that case is going to be pending. If it's a work permit, it tells you how long based on where you are, based on type of petition. So clearly 4 years waiting for an I-130 to be approved is not normal. So I was so excited for my client. We got that for him, and we're now able to move to the next step. So what I'm going to talk about today is things, regarding how to make sure that your case is moves faster. So having talked about filing a writ of mandamus, which is the best solution, really, I'm going to talk about other solutions that are less drastic. Some people just feel more comfortable doing that. So we'll talk about it. Okay. Hi, everyone. Hi, Ade. How are you? Where are you calling from, Ade? So let's talk about making sure that the petition that you submit has no mistakes, right? If you submit a petition on your own, you want to make sure that you don't make certain mistakes which will delay your case, because if you make these mistakes, USCIS will reject the paperwork. Either they'll reject it and return it to you, or they'll send you an RFE, which is a request for evidence. And an RFE can delay your case for a significant amount of time. So you want to make sure that when you send in your petition, if you're not using an attorney, you want to make sure that you're doing a near perfect submission, really a perfect submission. So let's talk about some of the mistakes that people make. The first one is making sure that when you file, say, I'm going to talk about this with respect to an I-130 petition, because I've seen this quite a bit. When you file an I-130 petition, which is an immediate relative petition for either your spouse, your husband, or your child, there's a certain page that it will ask you, I think it's page 8 of the I-130, I'm not sure. It will ask you whether the beneficiary will be adjusting status in the United States or will seek the immigrant visa in their country. And it will ask you to put the country where they're going to be seeking the immigrant visa if they're not going to be adjusting in the United States. Now, a lot of people make this mistake. They either check off both boxes, which is that the person is going to adjust their status. Adjustment of status means the person is in the United States already and intends to get their green card in the United States. Now, you have to make sure that the person can do that, because just because you're in the United States does not mean that you're eligible to adjust your status in the United States, right? And if the person is outside the United States, right, then they're going to be doing the application process through consular processing, which means they will be doing the application process in their own country. They're going to be interviewed in their home country. So this is really important, because if you don't designate, or you designate wrongly, like in the case of a couple of people that I've spoken to, I think it was supposed to be a consular process, and they either chose both or didn't choose consular processing. And so when the I-130 was approved, USCIS retained the petition. And that's not supposed to happen. If it's through consular processing, USCIS is supposed to, when the case is, the I-130 is approved, it's supposed to go to National Visa Center. So, and it's supposed to do this automatically. So once the I-130 is approved, within a couple of weeks, you're supposed to get an email or a letter from the National Visa Center giving you the information that you need to be able to log onto their portal and begin the second step of the process. But if you don't do this, USCIS keeps the case and they don't know what to do with it. And then you have to file something called a form I-824, which is asking requesting that some action be made on an approved petition. Now, the only problem with this is you're going to pay more money, because the filing fee for the I-824 is $465. And number two, the I-824 is delayed as well. So now you're looking at additional delays to your case. So this is one mistake that I want you guys to be sure that you're putting the information correctly. Now, if you're in the United States and you're out of status, you may not be able to adjust your status. it depends on how you came into the country. If you came in through with an expired visa, you may be able to adjust your status if you're married to a U.S. citizen, or it's a parent who's filing for you and you're under the age of 21, or it's your child who's over the age of 21 who's filing for you. If you're not in this category, is called the immediate relative petition, then you would have to wait for your priority date to be called, and that puts you in the preference category, which means that you have to be in a proper legal status to be able to change your to be able to adjust your status. So if you're on F1, you could adjust your status even if you're married to a green card holder. But if you're not, then you have, say if you have a sibling filing for you or a green card holder spouse filing for you, you may need to leave the country and proceed through consular processing, or you can wait for your green card holder spouse to get their green card. So there are different scenarios, which I don't want to make this complicated, but basically you want to make sure that if you're filing an I-130 petition, you want to check the correct designation as to where the beneficiary, what the beneficiary is going to be doing. So that also goes with all the other forms. If you're filing an I-765 and you put in the wrong code, that could delay your case. So that's one thing. Fill out those forms properly. So the second thing that will cause your form to be rejected by USCIS and have it sent back and delay your case will be sending it to the wrong address. You guys know that where you send the petition depends on the petition, depends on where the person lives, even depends on the manner in which you're sending the petition. Because if you're sending through FedEx or UPS, we use a different address. If you're sending it through USPS, it's a different address. If the person lives in a different country, in a different state, the address could be different if from another person who lives in another state. So you want to get onto the USCIS website, go to the form that you're looking to send, and make sure that you're sending your petition to the right address. Hi, I got a notice from Marcel Eric Sani. Hi, good morning. How are you? And then Ade says his attorney made mistakes on his petition. I'm so sorry to hear that, Ade. That's not good. So the second mistake that you do not want to make is not using the right amount of the fee, not paying the right fee. Every petition has a fee attached to it, right? And if it doesn't, if you go to USCIS website, it will tell you. For instance, if you're filing an I-130 petition, the filing fee is $535. If you're filing it with an adjustment of status, then the adjustment of status is $1,225. And if you include the filing fee for the I-130, which is $535, that comes to $1,760. And you want to make sure that you're addressing it properly. USCIS is really, they're really picky about how your checks are addressed. It has to be U.S. Department spelled out of Homeland Security. So don't abbreviate it to DEPT. They don't like that. Now, what else? You want to make sure you're using the right form. So if you use the forms on USCIS, like if you go on, you put in the information there, it's the right form. But what happens when you fill out the form, you mail it out, you hang on to it for a little while and then mail it out? That could be the wrong form because USCIS updates their forms. So you want to make sure that when you send out the petition, if you're sending it out by mail, that it's the right form. And they don't give you warnings when they're going to change the form. So you want to go check the edition to make sure it's the right form. So I have Lily Gabriel saying, thank you so much for the advice you gave during my consultation on my mom. You're definitely the best. Thank you so much, Lily Gabriel. It was a pleasure talking to you and your mom. Okay. So let's see what else. Let's go back to what else you should not be doing to make sure that your case is not delayed. Now, not including a required document, right? Say, for instance, you're filing an I-130 petition for your spouse. You have to have the marriage certificate because how does USCIS know that you're married? And if you've been divorced or your spouse has been divorced, you must include the divorce decrees, judgment of divorce, not the summons or the complaints. that, what was issued with the divorce, the judgment signed by the judge saying you are uncoupled. All right. So that's important. Now, I talk about this all the time. If you're from certain countries that are known for having fake divorces, don't do it. All right. That's a problem for the whole case, the entire case. So don't let anyone convince you that it's quicker to go a certain route if you're not sure that's a legal route to get a divorce. So if you're filing a petition for a spouse, you have to have the marriage certificate, you have to have the divorce decrees if anybody has been divorced. If you're filing for your child, you must have the birth certificate so that it's clear that you are the parent and the beneficiary is the child, or vice versa. Okay. Now, the other thing is when you submit documents and they're not in English, it must be translated, right? So you have to have the original, well, the document in the language that it came with, and then you have to have it translated. And the person who translates it must certify that they are able to understand that language and English and can translate it properly. So if you go to, there are places where they do these translations, they know what to do, but you want to make sure that you're attaching the document and the translation together. All right. So the other thing that you want to make sure that you do is to sign and date your document. This is really, really, really basic. Sign your document. USCIS requires black ink. I don't know that they reject if it's blue, but they require black ink. So to make your case, to give yourself the best leverage possible, just follow the rules. Use black ink, okay? And it has to be a signature, not an electronic signature. They will return it if it's an electronic signature, all right? So those are some of the things you need to do. I'm sure there are many others, but those are some of the things you need to do to make sure that your application is being properly filled out, all right? So if your case is being delayed, you haven't heard from USCIS, the other things you could do, right? You can send a letter to them, address it to the address in the receipt that you receive. Because when you file an application, you receive a receipt that says we received it. So typically I will say attach that receipt to your to the letter, and make sure that the address is going to the receipt, to the place where the receipt, to the address on the receipt. And you want to explain why you are, why you're looking for them to move on the case, when you file the case, how long it's taken. In your letter, present the narrative, present the argument that that is the reason that you're reaching out to them, right? You can also do something called an e-inquiry, which is online. You go online, you reach out to USCIS through an e-inquiry so that they can look into why the case has been delayed, right? Or you can also call them, the 800 number. You can call the 800 number. When you get a live voice, they will typically, you will ask for a tier 2 officer, right? And typically they will tell you that they will get back in touch with you. They'll review your case and get back in touch with you and tell you what needs to be done. So I can tell you that my clients and many other clients have not always been successful doing this, calling, USCIS, doing an e-inquiry or sending out in the mail. USCIS is so backlogged. COVID is one of the reasons, and I guess the amount of applications they get, and other reasons, but the backlog is really serious. Even though I have to tell you, in the past couple of weeks, we've gotten some really great success. We've gotten a VAWA case that was approved within 9 months. That's like unheard of. The processing time for a VAWA case is 2.5 years, 2.5 to 3 years. So 9 months is amazing. And we're really, really, really grateful and happy for our clients. So I'm hoping that this means that, USCIS is, maybe they're getting a hold of the backlog. I don't know. I mean, we've gotten work permits that were approved in 28 days. And typically it takes 6 to 10 months. So I'm really happy. We've gotten just a lot of things approved really fast, a lot of quick responses from USCIS. So I'm hoping that the trend continues. But if it doesn't, this video will tell you what to do. So now, what else? Another thing you might ask for, if you may request an expedited, if you may request that your application be expedited if there's a reason for that. For instance, if you have severe financial loss, right, or urgent humanitarian needs, right, or there's a compelling U.S. governmental interest that requires you to, expedite it, or there's been USCIS error. Now you have to remember that if the reason for the delay is your fault, they're likely not going to expedite it. All right. So you can expedite it even if it's not past case processing times. If there's, one of these four options that I've discussed. So what else? Congressional assistance is another way to get your case moving. If your case has been delayed, you've not heard from USCIS, you can reach out to your congressman to get their assistance. Typically, you can reach them by email or you can reach them by phone. I recommend sending out an email, and they will reach out to you, give you a form that each congressman does it a different way. So they reach out to you, and then you have to sign some of their forms, which give them the authority to talk to the USCIS on your behalf. I can tell you that people have had varying success with the congressional assistance, because it really depends on your congressman how vested they are in helping you. Some congressmen are more active than others, but the one thing that will not fail and is most likely the best way to expedite to get your case moving if it's been stuck is filing a writ of mandamus against USCIS. And like I said before, filing the writ or filing the lawsuit against USCIS does not guarantee you that your case is going to be approved. You're only filing so that they can get moving on your case because it's been too long. Okay, so let me answer some questions, and it's 11:18. I need to go. I have a meeting. So Babatunde Peterson says, what is the best to do between marriage or fiancé visa to get my fiancé here, ma? Now, Babatunde, this is a loaded question. I actually have a video on it because there are pros and cons. And I don't have the time to go into it, but there are pros and cons. And I have a video that discusses both. If you can go to YouTube, just do a search. I talk about the pros of doing a marriage visa and the pros of doing a fiancé visa. But one thing you don't need to consider anymore is time. The marriage visa and the fiancé visa are taking about the same time. So that's not in the past. The fiancé visa was shorter, and people would do a K1 visa because it was quicker. That's not really the case anymore, because during COVID, most places were not even processing the fiancé visa. So the fiancé visa is really backlogged. So typically I give my clients, during a consultation, I give the pros and the cons, and they make a decision because it depends on their circumstance. For instance, if your fiancé has children who are under the age of 21, it might be better to bring them here through a fiancé visa because they are derivatives. Through a marriage visa, you have to file separately for each person. So unfortunately, it's 11:20 and I just missed my 11:15 appointment. I have to run. But call my office, Babatunde, 973-993-1900. Let's really delve into this matter for you, and we can discuss what is the best option for you. Okay? Well, you guys, thank you so much for joining me. I'm going to sign off now, and I hope to be back again tomorrow or sometime next week. Okay? Take care.